right now if you want.
All right, so hopefully we are live now. We were supposed to do this this past Tuesday. We had some technical difficulties. Hopefully those have been resolved. So thank you very much for joining us. I'm Lior Samfiru, along with my colleague Lumi Pungea.
Hi.
And we're feeling a bit awkward here and standing in front of a laptop, but hopefully we can talk to you about some interesting things here. We're employment lawyers. We work with Samfiru, Tumarkin, and we work with employers and employees to help them understand workplace rights and help them enforce those rights where needed. And what we find always is a lot of misconceptions when it comes to workplace right, when it comes to employment law. If you go online, you go on Google, you'll find a lot of half-truths, incorrect assumptions, and if you believe those things, that can cost you. So what we want to do, the purpose of this broadcast is to give people the actual truth, tell people how things are, things you need to know if you're working, things you need to know if you have an employee, if you lost your job, if you're letting someone go, and hopefully that could be very valuable. We would like to do this regularly. Hopefully we can move on and make this a regular segment that we can do. And before we get started and talk about what our topic today, let me throw out a couple of pieces of information for you. Number one, a tool that we created that is a great tool if you ever lost your job, the severance calculator. It's severancepaycalculator.com. If you lost your job, it's the first place you go to. Go to severancepaycalculator.com. You can find out exactly how much you're owed if you lost your job. You input your name, your position, and the length of your employment, and it's going to tell you how many weeks or months pay you are owed. It's a great tool because it simplifies things. And if you're sitting there with a severance offer in your hand, you need to know if that severance offer is adequate. You know, maybe it's Friday at 8 o'clock and there's no one to talk to. Well, guess what? You can go to severancepaycalculator.com. Or maybe you haven't lost your job, but you've always wondered what you'd be owed if you ever did lose your job. So again, you can go to the severance calculator. The second place I'll tell you about is if you have a question, you want to ask it anonymously, you don't want to call us, well, guess what? We've created a website for that, terminationquestions.com. Again, terminationquestions.com. Ask questions online anonymously. One of us will usually answer within a few minutes. And so use that. And of course, if you ever want to call us, give us a call anytime, 416-216-15900. Now, enough about that. Let's get to the topic today. We have an interesting topic here this morning, talking about the worst times employers can choose to terminate employment. The worst times employment can be terminated. Lumi will tell us more about the topic, and then we'll get into it.
Yes, and just to follow up on something you said at the beginning, this medium is another way for us to interact with employers and employees. So is our Facebook page. The Google Hangout that we're doing today is meant to be interactive. So if you have questions, of course, just fire them away. We will address them today. The other thing I wanted to add is that we're trying to make the Google Hangout today and in the future as practical as possible. It will not be about obscure areas of law. It will not be about cases that only draw the attention of the lawyers. We're going to try to make practical points, and we're going to try to convey simple, direct information that you can apply to your own situation. That said, remember, this is not legal advice. It's meant to convey general information. Every situation is unique and different, and call professional, call lawyers, seek legal advice if you before you make any decisions pertaining to your circumstances. So on the topic that we're going to cover today, we're going to talk about worst times to terminate an employee. And again, it's meant to be relevant to employers and employees. And we're going to talk about situations where, well, the general rule in employment law is that an employer is free to terminate someone for any reason, for no reason, really, as long as adequate severance is paid. However, there are instances where that will be more closely scrutinized by the employees, by the lawyers that hired by the employees, and by judges ultimately, if the case gets in front of a judge. And so you have to be prepared to, as an employer, you have to be prepared to justify your decision making and to provide reasons that withstand scrutiny. Not doing so exposes employers to significant liability, because employees may be entitled to additional damages in addition to the damages that are generally awarded in employment law, which is notice or pay in lieu of notice. So again, from the employer's perspective, it's a great idea to document things and have reasons for the decision to terminate someone in certain circumstances. And those circumstances are, for example, if someone is announcing a leave, medical leave or pregnancy leave, or if someone is in the middle of that leave, or upon immediate upon someone's return from a leave. And so those situations can be what we call here legal minefields, and you have to tread carefully, and you have to seek legal advice. Lior, just to give you a map of what we're gonna the specific subtopics that we're going to cover today, Lior will go over situations when employees are in the middle of a disability leave or return from a disability leave. Then I will discuss situations like pregnancy-related circumstances. Then we're going to cover the situations where employees raise harassment complaints or safety concerns to their management. Another subtopic today is, again, with respect to the timing of the termination. It applies to the time when the employee is due for a bonus, and there are also difficulties and challenges with terminating someone right after you get them to sign a new contract of employment. So we'll address all of those subtopics systematically. Again, if you have questions, anytime, just fire them. We will I guess, interrupt our flow to deal with those questions as they arrive.
Well, thank you, Lumi. And yes, let's start now listing some of the worst times employers can choose to terminate employment. So the first one, as Lumi mentioned, is when an employee inquires about going off on a medical leave or disability leave, or maybe they're on leave or coming back from a disability leave. So that's a very, very bad time. And why is it a bad time to terminate employment? Well, because at that point, it may look like the employer is terminating the person because of the medical leave of absence. And if that's the case, that is a human rights violation. With respect to human rights violation, it doesn't matter how much severance, how much compensation the employer pays, it's still illegal. An employer is not allowed to terminate employment because someone is on a medical leave of absence, going on one, or hasn't come back for a while. An employee, in fact, is allowed to be on a medical leave of absence for a long time, sometimes months, even years. And if that's the case, an employer has to allow them to return back to work and do everything possible to bring them back. That's very important. An employer cannot decide, well, this employee is going to be going off on a leave while, so we want to let them go. That's illegal. And an employer that does that would, other than obviously the usual severance, would also have to pay human rights damages. That's a very, very bad idea. Now, if the employer can establish that the termination actually had nothing at all to do with absence, well, then that would be legal. But I'm going to say that that's going to be very difficult. The optics are going to be very bad. If I have an employee coming to me saying, unfortunately, I've been diagnosed with a medical condition, I'm going to have to be off work for a few months, and I turn around and let them go and say, well, I was going to do that anyway. So that's always a bad idea. If you can avoid it, the best thing you could do is allow the person to go on a leave, when they are ready to come back to work, make sure that you do everything possible to take them back. If legitimately there's no position available for them, at that point we can look at a termination. But let's not be preemptive here. Time, even years in some situations, you still, number one, often have a right to your job. If you do lose your job, you have a right to severance. And if you lost your job while on medical leave of absence, that could be a human rights violation. So remember, employers, employees, bad idea, bad timing to let someone go while on medical leave of absence. Now, hopefully that's clear. In a similar vein, which Lumi now will address, what happens if an employer wants to let someone go when the employee is about to go on pregnancy or parental leave. Again, another bad idea. Lumi.
Yes, and the same rules that Lior just described apply to a pregnancy or parental leave. And really, employers are in a tough spot because there's a presumption if someone is terminated right before a maternity leave, for example, in the middle of a maternity leave, or upon immediate return from such a leave, there's a presumption that the employer discriminated. And so it's very difficult for employers to rebut that presumption and to defend against that presumption. And again, it's the type of termination that will attract a lot of scrutiny. And it's a type of termination that is more likely to be challenged by an employee. Someone who's in the middle of a maternity leave or about to go on, they may perceive unfairness or discrimination even when there isn't any. And so, again, it just makes people more susceptible to challenge the employer's decision and to seek legal advice. And so you have to be prepared for the scenario where you get challenged. You need to be able to show that your reason for the termination is not connected in any way to the decision to terminate that person. And I'll give a very specific example of how again, a termination in these circumstances can be used against the employer. For example, even if an entire department gets restructured, if the people in that department, individuals in that department, get the opportunity to, I guess, advocate on their own behalf to secure positions elsewhere, but by virtue of being absent, an employee on mat leave doesn't get the opportunity to I guess, lobby on her own behalf to secure another position within the company, that could amount to a discrimination. That employee may be able to prove discrimination. And so, again, there are no safe areas for terminations in the middle of a leave or closely connected to a leave by virtue of timing. And you have decisions along those lines have to be well thought out and have to be taken with legal advice in your corner, basically, after you've crossed the T's and dotted the I's. I believe that would be this topic. Now, again, it's very difficult to rebut that presumption, and employers have to be careful, and employees also need to approach their termination. At the end of the day, people need legal advice, and it sounds self-serving, but that is the bottom line.
Well, the rule that I always say when it comes to pregnancy or parental leave, and this is very technical, hopefully everyone can understand it, is you don't mess with a pregnant employee. You just don't, ever. So that's a good rule. And Lumi, on that topic, we just received a question. I'm going to paraphrase it here. It's apropos the topic we've been talking about. The question pertains to the fact that an employee was advised of the termination of her employment 3 months into the maternity leave because the position ceased existing. And the question is, can the employer do that? So let me give you my thoughts on that. Lumi, jump in if you'd like to add. Assuming that the position did in fact cease to exist, it may seem legitimate. But here's the concern. An employer has a legal obligation to bring an employee back from maternity leave. Assuming the maternity leave is 12 months, how can an employer know after 3 months whether they're going to have a job for the employee in another 9 months? So it's possible that today that employer may not have a job for the employee, but 9 months from now, they may have desperate need for that employee. So by terminating an employee 3 months into the maternity leave, irrespective of what the reason is, arguably the employer is breaching the Employment Standards Act, potentially the Human Rights Code. It's illegal. So because of that, the answer to the question is no, an employer cannot and should not do that. The time to assess the ability to bring the employee back to work is at the end of the maternity leave. We can't be too proactive. It's okay to advise the employee that, listen, today there's a concern about whether you have a position, but we're going to try our best to find a position for you when the time comes. That's okay. You want to give the person a heads up, but you cannot terminate someone now on the belief that 9 months from now, 6 months, 12 months, whatever it is, you're not going to have a job. It's a bad idea. Anything you want to add to that, Lumi?
No, I think you've covered it, and I believe we can just move on to the next item, which is terminating someone after the individual raises concerns or a complaint about harassment in the workplace.
And believe it or not, if I were to tell you that an employee shouldn't be fired whenever they've raised harassment allegations, you probably would say, well, yeah, that goes without saying. That's obvious. But I cannot tell you how many times we see that in our practice. Employees that are either suffering from harassment or misconduct on behalf of a coworker, maybe even their boss, they finally get the courage to raise that as an issue. They go speak with HR, they go speak with the boss, and then they're let go. So why is that, other than from an ethical and moral standpoint, it being bad? Why is it bad from a legal standpoint? Well, the reason for that is an employer now has a legal obligation to actively protect an employee from being harassed in the workplace, and beyond that, to investigate those harassment complaints and take measures. It's not just a moral obligation, it's a legal one. The Occupational Health and Safety Act makes it law. So what happens when an employer doesn't do that, and in fact, the employer not only doesn't investigate and take measures, the employer penalizes the very person that raises those allegations. Well, they've breached their obligations. They're now in violation of the law, they're in violation of the Occupational Health and Safety Act, so they may be liable for damages. They could be fined, there may be additional bad faith damages they may have to pay the employee. It's a very bad idea. So what should an employer do when faced with a harassment complaint? Well, number one, take it seriously. It may not seem on its face that it has legitimacy or merit to it, but an employer has to investigate. Take it seriously, take down all the information, speak with the person, speak with other people in the workplace that may have knowledge, investigate. Depending on the allegations, depending on who's involved, it may not be appropriate for the employer to investigate itself. It may have to bring someone out from the outside, an outside investigator that specializes in these things, to investigate and determine whether or not the employee in fact has been harassed. You have to take it seriously, and you cannot under any circumstances penalize an employee for bringing those allegations up. And think about the message that would send to the other employees, who, by the way, are going to know about it. So someone had the courage to raise harassment allegations and they're fired. Would that lead to a productive workplace environment? Probably not. A very, very, very bad idea. So I never recommend that. Now, if you find that at the conclusion of the investigation that the employee on purpose brought a false harassment complaint because they wanted to get back at someone, well, at that point, that may be some cause for discipline. But those are going to be extremely rare. So the message, the lesson here is, let us not terminate an employee because they've raised harassment allegations. Even if it turns out that they cannot substantiate those allegations, you cannot and should not let them go for bringing them up. You have to take it seriously and investigate. And an employee, if you're in that situation, if you're, number one, not comfortable raising those allegations to your employer, or you've raised it and you don't feel they've been properly dealt with, give us a call. We can help with those situations.
I would just add to that the same applies to instances where employees raise safety concerns.
Absolutely.
A construction worker raising a safety issue on the construction site. Again, think about the message that the other employees would get if someone is terminated shortly after raising that concern, even if the decision for the termination is not related in any way to that concern, even if the decision had been made days, weeks in advance. I guess whistleblowing employees should be treated with, carefully. And again, the idea is that you don't want to convey the message. You don't want to allow the optics to be that the company retaliated against the employee for complaining about harassment, safety, or other inappropriate practices at the company.
100%. It's illegal, and it creates just a very bad workplace. So probably one of the worst things an employer can do.
Unless we have other questions, we can move on to the next scenario, and that pertains to situations where it can be perceived from the outside that the employer strategically chooses the timing of a termination to avoid paying an employee a hefty bonus. And so, assuming that somebody earned bonus for the previous year, let's say 2015, and the bonus is payable on April 1st, if the termination is effective, let's say March 31st, big red flags get raised on the part of the employee. And then again, if the case gets in front of a judge would not look favorably at it, and it will scrutinize, he or she will scrutinize the timing very, very carefully. Now, with respect to bonus, cases are all over the map, but really the general rule is that unless there's specific language in the contract that allows an employer to withhold bonus from an employee who is not actively employed at the time of termination, bonus is part of the compensation, and is part of the termination package at the end. And so I guess the first lesson here is you need to, as an employer, you need to take a close look at your contracts. Be aware of the fact that verbal contracts generally have implied terms that favor employees with respect to bonus and other matters. And so if you find yourself in the position where you have to terminate someone, again, avoid the scenario where your decision can be perceived from the outside as self-serving and strategic for the purpose of avoiding having to pay bonus. Terminations in this scenario are more problematic for long service employees who have historically received bonuses, who have come to rely on those bonuses as part of their compensation. And the bonus constitutes a significant proportion of the overall remuneration. And so in those cases, even when there is explicit contract language that allows the employer to let an employee to not pay bonus in the event of a termination, courts look at the fairness of the situation. They look at the equities of the case, and as we know, judges are biased, and so depending on their biases, they will bend over backwards to help an employee whom they perceive has been unfairly treated. And so again, terminations where timing seems to have been strategically chosen by the employer to shortchange the employee are very, very problematic and may attract not only payment of termination pay, including bonus, but other types of moral damages that can, again, create significant liability for the employer.
And it's also not effective. You cannot pick a convenient termination date that way. If you have a bonus that's due in April and say, well, I'm going to be smart, I'm going to terminate someone in March to avoid that April bonus, well, guess what? You know, the law will see through that. We'll see that you've picked a convenient date, and it's going to be ineffective. So other than the fact that, as Lumi said, that it may actually be worse in the sense that you may have to pay additional damages, it's just not effective. It doesn't work that way. Now, Lumi, I'm getting a bit jealous here because it looks like the questions that we're receiving have to do with your topic. So we received another question, and I'm going to paraphrase. Essentially, the question is, can an employer have a policy in place that says that the bonus is completely discretionary and decide not to pay the bonus? Well, this is something that we deal with very, very often. And let me simplify that as much as possible. A bonus is discretionary if in fact it's discretionary. It's not discretionary because there's a document that says it is. If you receive a bonus every year, you know how it's calculated, you count on it, then it doesn't matter what the document says. It's not discretionary because the reality on the ground is that you get this bonus. On the other hand, if sometimes you get a bonus, sometimes you don't, sometimes it's a lot, sometimes it's very little, then clearly at that point it is discretionary. The employer decides from year to year and situation from situation how much bonus to pay. So it is discretionary. So remember, a document that says that is discretionary is not going to overrule and override the reality on the ground. And the other thing I'll say about a document like that, a policy, a bonus plan, a document like that does an employer no good if the employee has not seen it. So if you have a bonus plan that talks about when you have to pay bonus and when you don't, but the employee's never seen it, the employee's never read it, never accepted it, it doesn't do you any good. A policy is useless if it sits in a drawer in the HR office and you take it out only when it's convenient. So if an employer, if you want to have a policy that you can rely on, it's your job to circulate it amongst employees. Make sure the employees read that policy. Make sure the employees accept it. And then maybe you can rely on it. Don't just use it and take it out of the drawer when it's convenient to you. The law is going to look at the reality and the relationship you've had with the person and not going to care so much about what the piece of paper says if the employees never accepted it. That's very important with respect to bonus. Oftentimes, employers try to avoid paying bonus as part of severance because they say, well, we have a policy that says we don't have to pay it. In most cases, a policy like that is not going to be effective in avoiding paying the bonus. So remember that, employees, if you're let go, your bonus, all forms of compensation, should be included as part of your severance on a go-forward basis, and it's not just your salary. Anything to add to that, Lumi?
I was just going to say that passive circulation of a bonus policy is not sufficient. Putting someone on the internet without announcing it properly, without having town hall type discussions about the terms of that policy, especially when terms of the policy are perceived to be adversarial to the employee, it's not going to be enforceable. Again, judges look at the reality on the ground rather than the formalities of a policy, and again, passively circulating a policy and relying on it is not gonna help when it comes to defending a claim. The other point I wanted to and it's a general point about today's topic. Just because there are measures you can take to protect your interest, employers, doesn't mean that that you can prevent a claim from being made. And so the topics or the pointers that we're giving today, again, are meant to proactively protect you, and they're meant to be used in defenses. But really, the fact that you can successfully defend a claim doesn't mean that you can prevent one from being made and avoid the expenses that come with with a challenge.
Yeah, the best way to avoid claims is following some of the rules that we've talked about and avoiding some of those pitfalls or legal minefields, as Lumi has said. And another one that I'll address right now, probably our last topic in terms of the worst times that employers can choose to terminate employment, is when an employer reduces the employee's compensation or changes their terms of employment otherwise and then lets them go. And let me set a scenario for you. And this happens very often. An employer may get an employee to sign a new employment agreement, and one of the things that that employment agreement may do is reduce the amount of future severance that the employee would get. So I may tell Lumi, I want you to sign this new employment agreement. Lumi may sign it, and she may or may not realize that what that agreement does is it reduces her future severance. But if I then turn around a week, a month, whatever it is later and say, now I'm going to let you go. And by the way, remember a month ago when you signed that agreement, now I don't have to pay you as much severance because I was smart. Well, guess what? The law is even smarter than that. And the law is not going to allow you to get away with that. If you knew when you were entering into this agreement that the reason you're entering into this agreement is to try to let Lumi go, let your employee go by paying them less money, well, that's bad faith. You enter into that agreement in bad faith. So not only will that agreement not be enforceable and not help you, but you may also have additional damages you have to pay. The same thing with reducing salary. So employee, unfortunately, we have to ask you to take a 10% pay cut. Okay, well, I'm not happy, but I'll take it. You turn around and then you let the employee go. Say, well, now I have to pay you severance, but I have to pay you severance based on your lower salary because you took a 10% pay cut. Again, it doesn't work that way. If the employee took the pay cut or you asked them to take the pay cut knowing that you're going to be letting them go, that's bad faith. Now, if you're legitimately entered into a new agreement with them in good faith, believing that it's going to work out, and then something happened that made you have to let them go, maybe that's fine. But the presumption is going to be that if you change the terms of employment only to let the person go, relying on that change of terms of employment, that there's something else that's not so kosher that's going on here. Avoid that. You may be liable for other damages. So if you know you're going to let someone go, now is not the time to change the terms of employment. Now, it's extremely important for every employer to use employment agreements. So I highly, highly recommend that to everyone. Every employer that ever hires an employee, whether it's an entry-level position or a senior position, should have the employee sign an employment agreement before they step foot into the workplace. But that's the time to do it. If you're going to change the terms of employment or have the employee sign an employment agreement when they're already working for you, you have to do that in good faith. You can't do that to try to get some sort of an advantage, or try to pull one over the employee. That's something that the law is not going to look very favorably on. So we'll have a topic more dedicated to employment agreements in a future segment. We'll talk about what agreements should say from an employer and an employee standpoint. But again, you can't use an agreement to try to minimize your liability when you know you're going to let an employee go. Very, very bad idea. So those are some of our suggestions, some of our topics were probably the worst times employers can pick to terminate employment. Now, this is not an exhaustive list by any stretch. These are just some topics that we deal with very frequently. It always makes us shake our heads and thinking, what was the employer thinking here? But there's other topics, and we'd be happy to take your questions. Feel free to contact us. You can always go to our website, stlawyers.ca, get our contact information, call us 416-216-5900. Go to the severance calculator, go to terminationquestions.com. We make it as easy as possible to get a hold of us. Lumi's very nice. I'm not so nice, but generally we're not too bad. It's easy to speak to us. So Lumi, how do you think our first segment here went?
Not too bad. Not too bad.
We're getting better. We'll get better as time goes on. Okay?
Looking forward to the next one.
So thank you very much, everyone. Enjoy the rest of your day, and we'll see you next time.